Two things are very important in dealing with owner-operators. One is your contract, and the other is how you handle them for workers' compensation policy. If your owner-operator contract is not 5 to 7 pages long, you better check it. If you've got a 1 or 2 page contract and you're dealing with owner-operators, if you've seen this morning, you have a serious problem, I'm telling you. And if you're local, and I'm not down on local attorneys, but if your local attorney drew up your contract, you need to have it reviewed by an attorney that does nothing but transportation, like Scopolitis or Dennis Corey Porter and Smith or Rob Mosley or any of those. We've got a lot of names we can give you. That's extremely important in today's world. I mean, extremely important. You can get in all kinds of trouble. You can get in all kinds of lawsuits dealing with owner-operators if your contracts are not written specifically. The second thing I would suggest you do, how many of you operate off of a tariff? How many of you have a tariff? How many of you know what a tariff is? Okay, if you don't have a tariff, I would also suggest that you get that same attorney to draw up a tariff for you. That's important. It protects you. It protects the exposure that you have with cargo and stuff. You may not ever use it, but there are times when you can. And it can save you money and save you losses. Workman's compensation, you've heard 2 attorneys this morning talk about it to some degree. They gave you the legal aspects of what can happen and what can't. We're going to talk a little bit about the everyday deal with work comp. Work comp is one of the, if not the, most complicated issues that we as insurance agents deal with, and that you as trucking companies deal with because a lot of you have owner-operators. It gets very complicated. People will get in fights, and they argue with auditors, and everything can go wrong. So what I'd like to do this morning is sort of try clear up a little bit of that for you. You know, you go into an insurance agency and you buy a truck policy, and it covers all 48 states, and tort law is all about the same in every state. There are some exceptions. You carry $750,000 or $1 million based on the type of authority that you have, which is no more authority, or $5 million based on whether or not you're hauling hazardous. Work comp is totally different than that. You don't go in and just buy a work comp policy for Tennessee. All the policies are the same, but how you set the policies up depends on whether or not you have coverage or not. And so we're going to try to explain that a little bit this morning. If you have questions, hold up your hands. If I can't answer them, Rex Raines can, because he's been there and done everything in the world with work comp. He knows all about it. So workman's comp is complicated for one reason mainly, and that's the fact that it is a statutory coverage. What does statutory coverage mean? It means that it's covered and driven by state law. Okay? There are 50 states in this great nation of ours. Every one of them have a different work comp law. Every one of them has, these people are covered and these people are not. This is what you pay and this is what you don't pay. This is why you have to have it and this is why you don't have to have it. So as agents, we have to design your work comp policies to cover you in every state you run in. And so we have to have all this information, locations and what you do and where areas you travel to so that that policy can be designed, because you don't just deal with the state that you're based in. And so it becomes very, very difficult to know what you really need. Statutory says, okay, Mr. Trucker, here's who you have to cover. It says, this is when you have to cover them. Then it says, this is what you have to pay when people are hurt. And this is what you pay for disability and for medical. And when you have to pay them. And so you've got to put all that together, which makes it very, very complicated. It means that also that in most states, in fact, in every state in the union other than Texas and New Jersey, workman's compensation is mandatory. Absolutely mandatory. And if you don't carry it, you can have serious problems with each state government. There are 2 states that says it's up to you. If you want to cover it, that's fine. If you don't want to cover it, that's fine, and that's Texas and New Jersey. Texas says, we don't care if you carry it or not. New Jersey says, we don't care if you carry it or not, and everybody says, yay, we don't have to carry it. But what happens when you don't carry it is you then become subject to tort liability, which can be extremely more serious than work comp, because now those people can sue you for unlimited amounts of money, and you have to pay it if they win on tort law. So you should always, always carry it. States tell you not only that you have to carry it, but they tell you when you have to carry it. Some states say, if you one employee, you have to carry it. Other states, like Tennessee, says 5 or more. Some states say 3 or more. But once again, if you don't carry it in those states, you're subject to tort liability. Very serious, very serious. So you really need to always, always carry it. If you don't carry work comp in those states that make it mandatory, you are subject to a fine. In Kentucky, it's $10,000 per visit. That means if the Department of Labor comes by and checks Pete Gunn Trucking and I don't have work comp and I should have it, they can fine me up to $10,000. So they come back next month and they say, did you get it? Well, no, I forgot to. Another $10,000. And that can go on and on and on until you purchase workers' compensation. Tennessee has penalties also. Alabama, all the states around us, every state has penalties for not carrying work comp, and some are really costly. For example, in Alabama, if you don't carry work comp, and you have locations there and you don't carry it, they can fine you up to 2 times your annual premium. Now think about that. Trucking companies have $30,000, $40,000, $50,000, $100,000 premiums, and Alabama says, okay, you owe us 2.5 times. Well, wait a minute, that's $250,000. They're serious about you carrying workman's compensation, just like Kentucky and other states are. Coverage, as I said, is compulsory in almost every state in the union, except Texas and New Jersey. And the thing we overlook a lot of times about work comp is when we don't carry it, not only are you subject to fine, but if you look at the work comp laws in every state, you are subject to criminal charges. Personally, in your company, and corporately. So if you're not carrying work comp and they audit you and you don't have it, not only are you going to pay a fine, you can be subject to criminal charges because you don't carry it. And in addition to that, some states, it's a felony if you don't carry it. So you begin to see how serious states are about this. Work comp is basically a social coverage, insurance coverage. And what that means is that the employer takes care of the employee. The employer is not subject to the fines, is not subject to anything other than taking care of the people through their work comp. And so in exchange for the employer taking care of the employee for injuries and for disability and for death, in exchange for that, you have a known cost. That's the premium. And you have this known cost, and then the employee gives up the right to sue you. So it takes it out of tort liability. So if you don't carry it, you can get sued and you're liable to end up in court for tort liability. If you do carry it, the employee has it's called the sole remedy. That's their only remedy against you, is work comp. So you're giving up the unknown, a big lawsuit, for a known, the premium. And that's can be very costly if you don't do that. If you don't carry work comp, not only are you subject to the fine, not only are you subject to possible criminal activities, you have to pay the claim. The state law says, well, if you're not going to carry it, you still got to pay the state claim, the claim that the employee has. Now, most claims are small, maybe $2,000, $3,000, $4,000. But when you stop and think about what your exposure is, it gets astronomical. For example, a death can result in somewhere up around $250,000, right, Rusty? In most instances, in most states, it's about $250,000. Not only that, if it's just an injury and the employee is off work, you're going to have to shell out about $400 to $500 a week as long as that person is disabled. If they're permanently disabled, you're going to shell out that $400 or $500 a week until age 65 when they're eligible for Social Security. But that's not the big one. The big one is almost in every state, the medical costs are unlimited. So if Bruce is not carrying it and he has a work comp claim and the guy's laid up on life support for 30 or 40 days in the hospital, and then for the next 3 weeks he's in intensive care, what do you think his hospital bill is going to be? $300,000, $400,000, $500,000. He has to pay that. And if he can't pay it, they'll sue him for payment, and now all the assets he's got are exposed for work comp purposes. So the states are serious about this, and they will make you pay. Statutory defines who is an employee and who is not, and that's the controversial part. Are we covering owner-operators or are we not? Are owner-operators susceptible to work comp or are they not? You heard her talk about all the complications involving in owner-operators. Kentucky says an owner-operator is an employee, basically. Tennessee says, no, they're not. No, they're not. You don't have to insure owner-operators in Tennessee. And so Kentucky, right next door, says you have to. North Carolina, right next door to that, says you have to. South Carolina right there says, no, you don't have to. Georgia says you don't have to. Alabama says you don't have to. The problem is, how many states are you running in? Which state are you going to have the loss in? Where's the employee going to get hurt? You know, he could get hurt in Tennessee. We don't have to cover him, but he's going to get in that truck and do what? He's going to drive to North Carolina and say that's where he got hurt. And North Carolina says you're going to pay because he's an employee. And so that's the reason you carry the workers' compensation. And the states are the ones that determine that. And you say, well, okay, all I have is owner-operators and I'm in Tennessee, so I don't really have to carry it. Well, let me complicate that a little bit for you. Old South Freight's based in Tennessee. They use owner-operators. They don't have to carry work comp because Tennessee says they're independent contractors. However, that's not the only state that they operate in. And when somebody gets hurt, an employee or an owner-operator gets hurt, they have a right to choose from the following: state of hire, state of injury, state of residence, or state of assignment. Now, they may be hired in Tennessee, they may live in North Carolina, but they're hurt in Kentucky. They got 3 states they can choose from, which one they want to cover, which one they want to file their claim in. And they can file it in Tennessee, but they're not going to get anything because they're an owner-operator. But they can file in Kentucky too. And Kentucky will say, pay it. North Carolina, if you even get close to North Carolina, you got to pay. I'm telling you, that is a tough state. They made it Rule House Bill 489, I think it was, and I thought this law really can't be this bad. So I called the head legal counsel for the Department of Labor, Division of Workers' Comp in North Carolina, and I asked her, I said, would you explain this law to me? And she said, I'll make it really simple. You're hurt anywhere near North Carolina and you're going to pay. I don't care if you're an owner-operator or you're an employee, it doesn't matter. We're going to make you pay. I said, well, what about just drive-throughs? If you're hurt in North Carolina, you're going to pay. And so we have to design your policy to make sure that not only do you have it coverage in your base state, but you've got it in all these other states you drive through, because you are susceptible to that. And you're susceptible to paying those same figures that I gave you if someone is injured. So we can't be sure from day one what state you're going to be susceptible to. We can't be sure what state your injuries are going to take place in, and so we have to cover all these states for you. And therefore we ask you all these questions, and I know y'all are sitting there when we're asking them, when are you ever going to quit asking these questions? But our purpose is to find out every state you operate in, every state you have a location in. Well, I have a location in Tennessee. Well, do you have a salesman? Yeah, I have a salesman. Where are they? Well, they're located in North Carolina. Okay. Would you have a recruiter? Yeah, where are they? Well, they're in Arkansas. So now you got 3 locations, and we got to have all of those designed to cover those people specifically under the work comp policy. So we need to know basically about everything that you're going to do. The state also defines who is an employee. And there's probably more controversy over this, as you saw this morning with these people, over who is an employee. Everybody knows when I hire a driver and put him in my truck, they're an employee. But what about owner-operators? What about owner-operators? About 15, or she said 24 this morning. I thought it was more like 15. States define owner-operators as independent contractors. The rest of them make them employees. And so if you have a work comp policy, you've got to cover in those states, you have to cover those owner-operators. Well, I don't want to cover them. Okay? So you don't cover them. You don't report their payrolls. Well, let me tell you how that works. We had an account in Kentucky that had a bunch of owner-operators and a bunch of employees. They reported all the payroll on the employees, but they didn't report anything on the owner-operators. This went by for 2 or 3 years, and Brett and I had a discussion almost every year about this. And so Brett would go tell this guy, you're going to get caught. You're going to get caught. We didn't write the work comp, thank goodness. But another agent did. We wrote all the rest of the account. Well, an auditor came by that was smart. And he said, I see all these trucks sitting out here owned by but leased to. You have owner-operators? Yeah, I do. Well, I don't see any payroll on here for them. Well, I don't report it. An auditor says you owe it. And so he did an audit for 1 year, and that audit was $100,000. But that was complicated because they can go back 3 years. And so this guy who had not been paying any, and we've been telling him about it on his owner-operators, you got to pay it, ended up with a $300,000 bill, and he had to pay it. So you need to clear those items up front. Are you going to cover them or are you not going to cover them? If you're not going to cover them, you need to move to a state that doesn't recognize owner-operators. Otherwise, you're going to have to cover them. She was talking a while ago about occupational accident. In states where owner-operators are not considered to be employees, then we would recommend that you carry occupational accident. And a lot of companies will write work comp on the employees and occupational accident on the owner-operators, and that works out great. But then there's some people who have only owner-operators, and so they only carry occupational accident. Don't ever do that. Don't ever. Rule number one, I don't know if y'all are familiar with NCIS, but what's his name always has rules, you know, Rule 51, Rule 14, and everybody knows. Rule number one is never carry occupational accident without work comp. Period. Period. You don't have to pay them, those people, if they're independent contractors, but what happens when they go to North Carolina, when they come to Kentucky, when they go to Arkansas, when they go to Illinois? They're going to be employees. Are they going to collect under their occupational accident? Yeah, unless their medical bill runs $2 million or $1.5 million, and then what are you going to do? Oh, well, you're going to pay because they're in a state that covers owner-operators. Are you willing then to risk everything you've worked for all your life not to cover work comp? That's not very smart, is it? So always carry work comp regardless if you just have owner-operators or not. Then you got this other thing that complicates this too in a lot of states. I'm an owner-operator and I own 10 trucks and I lease them to Music City Logistics. And Sue says, okay, do you have work comp? And I say, no, I don't carry work comp. I don't have to. Well, you do, but I don't carry it. And then Sue says, well, I need a certificate of work comp. Why? Because now then I've got 10, she's got 10 people who are uninsured subcontractors. Uninsured subcontractors. What does that mean? It means you're going to pay. That means you're going to pay. Because they are uninsured subcontractors that work for you now, even though somebody else pays them. And so you have to clear that up front. You either carry work comp or I'm going to charge it back to you, one of the two, because we've got to have it. And so if you've got independent contractors who lease you trucks with people in them, they're not independent contractors. Those people who work for me are not independent. They're not owner-operators. They are employees of Gunn Trucking, which makes them employees of Music City Logistics because I'm an uninsured subcontractor. So always get certificates of insurance from people who own trucks and lease them to you with employees in them. What really complicates this too is what this lady was talking about a while ago. I don't know. Do you realize that everybody that gets behind the wheel of a truck that's either leased to you or driven by somebody is an employee according to federal standards? Do you know that? You got the state saying, well, independent contractors are okay. You got the federal government saying they're employees. We recently had a case in Tennessee that covered that issue. We had two guys in a truck. The passenger driver was hurt. He sues the driver, who goes to the company. The company says it's excluded because we don't cover employee lawsuits interchangeable because their federal government says you're an employee. And the courts upheld that. But then he said, well, he wanted work comp. He said, no. Tennessee said, you can't have it. He's an independent contractor. So the guy gets hurt, collects nothing, but we have all this big lawsuit that ended up in the Supreme Court. Carry workers' comp, and you don't have to worry about all that stuff. You can also, work comp has also got a second section to it that's called employer's liability. If you have people who work for you who are married or who have relatives, you realize that those people that don't work for you but are related to this person can sue you. And they can sue you for loss of services, they can sue you for loss of consortium, they can sue you for all kinds of reasons. And so if you carry work comp, it has employer's liability on it and it protects you for that. If you don't carry work comp, not only do you have to pay the medical bills here, then you're facing tort liability from the family who sues you for all these other things. And so you've got a lot of exposure that the children can bring to you, that the wife can bring to you, that family members can bring to you. So you got the problem of owner-operators, you got the problem of who's an employee, you've got the problem of when do I have to carry work comp? What states do I operate in? What laws do I have to fall under? And then you got the problem of, well, what's payroll? What's payroll for owner-operators if I'm going to cover them? Well, it's 1/3 of the revenue that you pay to the truck. That's what they consider that. Or if you have a tax return, they can accept that. But for not only for independent contractors, for employees, it's 401ks, it's retirement, it's uniforms furnished. It's anything you furnish to a driver. Not only does his payroll count, but all those furnished items can be picked up too. Contributions to, what do you call that? Somebody help me, where you make contributions, you pay your babysitter and you can.
Safety counts, HSA.
A what?
HSA, health safety.
HSA counts, yeah. Contributions made to that by you for the driver is also considered payroll for work comp. So they're going to pick all that up. So you need to understand that before you start. You need to get that cleared up. Ask your agent, preferably us, but ask your agent, what do I have to pay? Who do I have to pay? How much is it going to cost me? And who do I have to cover? And get all of that cleared up front so that you don't have to have a big fight at the end. How many of you have brokerage operations? I'm going to hold up your hands. Okay, if you have a broker operation, that means you're brokering all this freight, out to somebody else. And that brokerage operation has to carry, must carry, should carry workers' compensation, shouldn't they, Rex? Because every truck you broker becomes an employee if they're hurt in a state like Kentucky, North Carolina, or these other states. So you not only have to have workers' compensation for the trucking company, you also have to have workers' compensation for the brokerage. If somebody gets hurt that you've brokered a load to in Kentucky and they don't carry work comp, it goes up the food chain and the Department of Labor will start looking for work comp. And wherever they find it is who's going to pay it. So you can have no employees and have a brokerage and broker to all these other people, you still better carry workers' comp.
He was hurt in Pennsylvania.
He was hurt in Pennsylvania, but he was hired in Kentucky, and so we paid him, didn't we? Yeah. Good example of that. So my point is, whether you've got employees or not in a brokerage, you still need to carry workers' compensation because you're going to end up paying if they don't. Therefore, it becomes mandatory that you get a certificate of insurance for work comp on everybody you broker a load to. Not only do you want their liability, not only do you want their cargo, but you also want work comp. And the reason you do is because if you carry work comp, if they don't pay it, you're going to. And if it's a state that covers that type of thing, which 30 states do. So you operate in a lot of those. If the injured employee or the injured owner-operator doesn't have the ability to pay, I promise you, you're going to end up paying somehow, some way. If you don't carry it, or if you upset people and are not carrying it, they will, in fact, turn you in to the Department of Labor if you make somebody mad because they're going to get back to you somehow. So you always want to carry workers' compensation. It's very complicated. The federal government concerns me in the fact that when they look at trucks now with independent contractors, they are getting very involved, not only in the work comp area with the states, but they're getting involved deeply with the wage and hour. They're looking for people who drive more than 8 hours a day and are not paying overtime. They're looking at owner-operators so that you will have to match the 7.5%. They're looking at you for any violations of the labor laws so that they can collect fines and revenue from you. They start a lot of times with the state saying, these people have owner-operators and they've got people hurt and they're not paying it, and so they end up working together. Workman's compensation is something you cannot do without. I don't care how many trucks you run. I don't care how many owner-operators you run. You can serve time in jail. You can pay huge fines. You can lose your business paying the expenses of the people who are injured. If I haven't scared you, that's why they told me I had to come today, to scare everybody so we could sell some work comp, huh? But anyway, if you're not carrying workers' compensation and you use owner-operators, you must do that. If you're not carrying work comp and you've only got one employee, it doesn't matter. You still must do that. You've got a defined cost versus an undefined award from a jury. Anybody have any questions? What are you raising your hand for? All right.
Can you speak to why the owner of a trucking company really should not exclude themselves from workers' comp?
Okay. As in most states, people can exclude themselves from work comp. I never recommend that. Never, ever, ever. And the reason I don't is several reasons. One is, if you're coming to work as an owner and you're hurt and you're injured, you may have health insurance, but you may have gaps in that. You may end up with a $300,000, $400,000, $500,000 medical bill, which would be covered under work comp and may not be covered under your hospitalization. It's not expensive for an owner to carry. There's a death benefit. There is medical benefits. There are other people involved. For example, if he gets injured or killed, his family may sue the company. May sue the company and collect under employer's liability if you're carrying work comp. It's not wise to do that because the owners don't cost much. It's all clerical or it's all management. And it's very cheap for an unlimited medical, for a disability, for a death benefit, and for employer's liability. Never, never exclude owners. I don't. I wouldn't recommend it at all. I know some people do. Very dangerous. Very dangerous. Anybody else?
Don't mention anything about per diem.
Sure. That's Diane's favorite problem. Okay. I'll touch briefly on per diem. Anybody know? Y'all know what that is? Under most workers' compensation companies, they will allow you, according to the IRS, to do some per diem. And that means that you're going to write a check to the driver for X number of dollars, and then you're going to write a check to the driver for so many dollars, $30 a day, $35 a day, whatever you feel like you can get by with, I guess. And that is not chargeable under work comp. Okay? So that's a way to avoid some of the charges for work comp but you need a dual check system, don't you? And you can't overdo it. You can't, $75 a day, most companies won't let you get by with that. The IRS says we don't care. There's no limit to the IRS. But insurance companies are not going to stand by and let you pay the driver $50 and then pay him $100 for per diem. $30, $40, $45 a day, you probably can get by with, and that's feasible. So you can set that aside over here, and that means that you're not paying work comp on that. Is that right, Rusty? You agree with that? Would you tell Diane that? Huh?
Disability or the lost wages is affected by that.
Yes. The downside to that is, thank you, the downside to that is disability benefits are payable at usually around 66 to 2/3 of the weekly wages of the individual who is injured. And that per diem comes off of that. So that's not included in the calculation of the 66%. That's the disadvantage to per diem. The advantage is you don't pay work comp on it, you don't pay taxes on it. You don't pay the 7.5% on it either. Federal government says that's okay. You don't have to pay any of those taxes. So you can save several dollars doing that. Anything else?
Also on that exclusion, too, that you can maintain like, if you're deemed hurt on the job and the owner has excluded himself, his hospitalization does not have to pay.
The hospitalization forms, if you look at all your hospital group forms, what it will say is if you have workers' comp or you are eligible to receive workers' comp, your hospitalization does not pay. So I could get hurt on a job. I'm eligible for group insurance. I'm eligible for work comp insurance. I just didn't take it. And the hospitalization is going to say, we don't owe it either. Okay? So you may have a $100,000 medical bill that you could have collected under work comp, but you can't get it under your hospitalization or work comp because you don't carry it. You excluded yourself on the one, and the other one says, well, you were eligible for it, so we're going to exclude that. What I've tried to do is cover the practical aspects of work comp, not legal. That's those people's job. But if you ever have any questions about it or anything, you can call us at the office, and we will be happy to discuss that with you. We're going to eat, I guess, now. Where at? Outside and in the parking lot, right? Come out, go out this door and take a right. And come back through this door. Okay, I'm already lost. Took me an hour and a half to find my hotel last night. I went by it 3 times before I knew I was there. Boy, getting old ain't fun. Thank y'all for your attention.